Well, hello everybody, and welcome to the webinar. My name's Claire Bottle. I'm the Chief Executive of the UK Warehousing Association, and I'm delighted that we're working with our legal specialists, Aaron and Partners, to bring you a series of webinars about important matters for our members. So without further ado, let me hand you over to Nick Toms, who's going to tell us about liens and what to do if your customer goes bust.
Thanks very much, Claire. Helen, if you could possibly share the slides. Thank you. Yeah, so my name, I'm Nick Clarke. I'm the senior partner and head of the dispute resolution and insolvency team at Aaron and Partners. And I'm going to talk today about liens and how you go about enforcing them. So the start point, really, and I appreciate this may be teaching some of you to suck eggs, is to address the question of what is a lien. So next slide, please, Helen. So very simple terms, a lien is the right to retain possession of goods belonging to another until sums due are paid. There are, as you might expect, nuances to that, and we'll look at some of those as we go along. And in this company, I appreciate that you are likely to be familiar with the concept of liens, but that is not necessarily true outside warehousing circles. So next slide, please, Helen. So the next question then is, how do liens arise? And there are broadly two ways. The first is as a matter of common law. So that's just the law of England and Wales. You don't need to do anything in order for a lien to apply if you meet the criteria that the law sets out for a common law lien to apply. And an example of that would be a repairer's lien. Another example, of course, is a warehouse keeper's lien. And I'll come back to that issue later. In very simple terms, we don't recommend that anyone tries to rely on common law liens because there's too much uncertainty around them. And so you are far better off relying on the second way that liens can arise, which is under your contracts with your customers. And as you would expect, the UKWA terms include provision for a lien. Next slide, please, Helen. So there are broadly two types of lien. There are particular liens, which secure sums that are due in relation to the particular goods in your possession. And there are general liens, which secure any sums due to you from that particular customer, whether relating to the goods that you're in possession of or other goods that you are no longer in possession of. And that's quite important because in any situation where you have stock moving in and out of store, it is, and particularly with credit periods in relation to invoices, it's quite possible that the goods that you are storing at any given point are not the goods that the debt that has arisen relates to. And so really what you need is a general lien. I said I would come back to the issue of the common law warehouse keeper's lien. There's some debate about whether that's a particular lien or a general lien. But it's best not to leave it to chance. It's far better to rely on the contractual lien in the UKWA terms. So next slide, please, Helen. So looking at the UKWA terms and what they say about liens, clause 6.5 of those terms provides for a general and particular lien in relation to all sums claimed by the company. And the company in this context is you as the warehouse keeper. And that's quite important. So it's not actually confined to debt. It is actually all sums claimed, and it can be sums prospectively due too. So it will include things like interest, ongoing storage charges, potentially charges that are incurred in relation to dealing with the application of the lien. So it's quite wide-ranging, and that of course is to your benefit when you're trying to exercise the lien. The major issue with this that we find in practice is that the lien is of course only any use if you have incorporated the UKWA terms into your contracts, and to do that you need to ensure that the contractual terms are understood in the sense of the customer knowing the terms on which you will deal before you start working for the customer. It's quite common to see people refer to the UKWA terms on the bottom of their invoices. And while that is something which we think is a good idea, on its own, it usually isn't enough. The reason being that by the time you send an invoice, in usual circumstances, you've already carried out the services. And to incorporate the terms, you need to do it before you start providing the services. So I've set out on the slide there the things that we would suggest you do in order to ensure that the terms are incorporated. That's refer to the terms in your quotes and send a copy of them with those quotes. Display the terms on your website and refer to your terms as being those on which you trade on your letterhead, your email footers, your invoices. So it's a sort of belts and braces approach, but the key point is that you need to bring them to the attention of the customer before you start work. Next slide, please, Helen. So we'll look now at enforcing a lien. I'm not going to talk about the practicalities of it. We issue a guide which is available to UKWA members about the notices that you have to give in order to exercise the lien. But I want to talk about some of the problem areas that can arise because these are the tricky things that we find come up. So I pose a question there. Can I exercise a lien if the goods don't belong to my customer? Well, the answer is potentially yes, you can. If the owner of the goods was aware that storage could be subcontracted and that the subcontract could be on terms that include a lien. In practice, what this often involves is looking at the terms that apply between your customer and the owner of the goods. So typically this might be a situation where you're dealing with a freight forwarder, another provider of logistics services that is inserted between the owner of the goods and you. So asking where you think that the goods might not belong to your customer, it is worth asking the question as to what terms your customer is trading on with their customer, the owner of the goods. And very often what you'll find, particularly with other logistics providers, is that their terms will permit subcontracting and that they will permit doing so on terms that provide for a lien. A sort of common formulation that you find in this context is a provision that subcontracting is permitted on any terms. And we have in fact run a case some years ago now, but it's still one of the leading cases in relation to the application of liens, general liens against owners of goods who aren't the customer of the warehouse keeper. And the conclusion in that case was that a formulation along those lines between the owner of the goods and the shipping line, as it was in that case, was good enough to enable our client, who was the wharfinger that unloaded the goods from the shipping line, to exercise the lien against the owner of the goods. In that case, it was a consignment of timber that came from Scandinavia, and the shipping line went bust, so didn't pay our client, and so the client wanted to exercise a lien over the timber. And because the owners of the timber had contracted with the shipping line on terms that said that services could be subcontracted on any terms, it was held by the court that we could exercise a lien. So that's the practical point there is where you're dealing with someone that probably isn't the owner of the goods. Check that out up front and get the comfort that your customers' terms do what they need to do in order to allow you to exercise the lien should your customer not pay. Next slide, please, Helen. The second area of interest in relation to enforcing liens is where the customer goes bust. And I'm talking about a situation here now where the goods do belong to your customer. So we put to one side a minute the situation I've just talked about. So if your customer goes bust, can you exercise a lien? Again, potentially yes, you can, but you do have to know what form of insolvency applies to the customer. And there are different kinds of insolvency, but for present purposes, two main types. One is liquidation and the other is administration. And there is a difference between the two in terms of how they affect your ability to rely on the lien. If it's liquidation, then there's no problem. There's no restriction on enforcing the lien. And the significance of that, of course, is that a liquidator is likely to want the goods because they're an asset of the company. They will want to realise them for the benefit of the company's creditors. And so you put yourself in a much better position than you would be as an unsecured creditor, where you would get pence in the pound, because you're entitled to say, no, I'm holding on to those goods until I get paid. And if I don't get paid, ultimately, I'm going to sell the goods. I'll come on to sale of the goods in just a moment. So liquidation, broadly, no problem with that. Administration is slightly more complicated because you can only enforce the lien if your customer is in administration with the permission of the court, or if the administrator agrees. Now, usually there's a deal to be done with administrators because they recognise that ultimately, if you do make an application to court, what is likely to happen is that the court will order the administrators to pay a sum of money into court to effectively substitute the security of the goods themselves for security over the amount of money, and that money then isn't paid out of court until the dispute is resolved over whether the lien can be exercised. Administrators generally are reluctant to do that, and quite often you find therefore that deals are done along the lines of goods are released on the drip so that the administrators can realise money by selling them, and that money is then paid to you until the debt is paid. The thing to watch out for there is that they don't cream off all the good stock and leave you holding stuff that actually has no value, and so you've then just got a different problem of paying to dispose of stock that nobody wants. If you are facing a situation where your customer goes bust, I think the most important thing to stress is that you should take specialist legal advice as soon as possible, because there are pitfalls if you get this wrong. So if, for instance, you simply refuse to deliver up goods to an administrator without going to court and without seeking their permission to hold them, then you can find yourself on the wrong end of a court application and potentially a costs order. So you don't want to turn a situation where effectively you have the upper hand in having the lien into a situation where you're actually on the back foot by not knowing the precise way to deal with this. So this is very high level stuff, but basically take advice if your customer is going bust. We operate a helpline for UKWA members, so you can call that, and if we can resolve the issue with a sort of initial call, then we will. If we can't, then we can look at what advice you actually need in order to deal with the situation and de-risk it for you. Next slide, please, Helen. So the third area I wanted to look at in terms of enforcing liens was the issue of what if the exercise of the lien doesn't produce payment, and that would often arise in the situation where the customer has gone bust, for instance. So question, can you sell the goods if the customer doesn't pay? Again, potentially yes, you can. The UKWA terms give you the right to do this. Now, there are some complications with it in terms of intellectual property rights in relation to branded goods. The argument from the owners of those intellectual property rights is usually that you can't sell them because doing so is an infringement of those rights. I'm not going to go into any detail about that now because time doesn't permit, but it's another area where, suffice it to say, if you find yourself in that situation, you must take advice and you need to do it quickly, because if you end up selling goods, either in that situation because they are branded goods and there are these intellectual property right issues, or simply because you're selling them in a way which doesn't comply with the way that you should actually do this process, then you can find yourself again going from that position of holding the whip hand to being on the back foot with it. And the last thing you want to do is end up with the owner of the goods saying, actually, we've got a claim against you for the value of them because you weren't entitled to sell the goods. The advice you would get at that stage would cover everything that we would need to be sure of in order to sort of give the go-ahead for selling the goods, including checking that the terms have been validly incorporated in the first place, because if they haven't, that contractual right of sale wouldn't apply. So all roads with this really lead back to that point about incorporating your terms and making sure that they are the terms that you're trading on with your customers. The UKWA terms generally are a real asset in terms of your trading with your customers, but they're only any good to you if you follow that advice and make sure they get incorporated into your contracts. So I think there I've probably talked for just about what was my allotted time. So I will open it up to any questions. Thank you.
Great, well, thank you very much, Nick. I don't know whether we have any questions. Let's just see whether there's anybody on the call who would like to ask anything. Doesn't sound like we have got any questions.
Stunned silence.
It must be a positive feedback on the fact that you've covered the topic so comprehensively. I think it's not really surprising, I suppose, to hear somebody from the legal profession recommending people to take legal advice. But having said that, obviously for UKWA members, we do have the benefit of the helpline which you operate for the benefit of our members. So yeah, I think that's really pertinent and useful advice. And hopefully not too many customers do go bust, but of course it's one of those things that it's quite difficult to plan for and sometimes difficult to predict as well. So it's good that the helpline's always there and there's always backup with the conditions of contract as well.
Absolutely.
Great. Well, I think that's everything for today. Thank you for organising the webinar. Thank you to everybody at Aarons, and thank you to those who are listening and following it. That's it from the UKWA.
Thank you.